So let's start with the final panel for today. The final panel is always a difficult panel because the speakers are perhaps tired and the attendees are tired because they really had many interesting presentations, but we have a very interesting topic, perhaps not as controversial as the other topics, but still a lot of discussions, for example, with the compromise on the Blue Card Directive. I thank Philip and Daniel and the others for convening such an interesting panel and also for the title. I think it's a good title to say A Fresh Start. Perhaps we will have a fresh start, or a stalemate, or a standstill for a certain period. And the other title is quite good as well, was the patchwork, or what I would say, the pick and choose possibilities for member states, especially when it comes to issuing titles which could be covered by the Blue Card Directive, but the right to reside is based on a national residence permit. We have selected areas covered by EU migration law, by the directives, mainly economy-driven when it comes to the Blue Card Directive, and it also comes to researchers, students, perhaps not in the same way, and also when it comes to seasonal workers, but these are not covered. Seasonal workers are not covered by long-term immigration, but of course, if they come repeatedly, there could be a tendency to integrate them, and we will see. I don't want to talk about the migration issues myself, but I would like to give the floor to our speakers. The Patching Up the Patchwork, a very good title, is the title of the speech which will be given by Professor De Lange from the Radboud University in the Netherlands. You have the floor.
Thank you very much, Ulrike. Good afternoon, everybody. Let's talk business with everybody who's left here. I think it's good, before we maybe have drinks, to talk business. The current EU legal migration acquis is made up of 7 directives on family reunification, long-term residence, it's been mentioned, the seasonal workers, the blue card has been mentioned and will be addressed further, intra-corporate transfers, students, researchers and trainees, and there's a single permit directive, a directive that doesn't, as such, deal with the admission of people for work, but deals with the rights of people who work. Not included in this list is a regulation of low-skilled, or I would rather say practically skilled people, or entrepreneurs. So those are 2 topics that are still open. In comparison to the EU asylum acquis discussed at length so far, the legal migration acquis has remained relatively stable. Legislative stability does not necessarily mean that implementation is good, and that the application of these directives in the member states is as intended. So this is why in the new Pact, the Commission has outlined to make the patchwork work and how they want to do it. And as been said before, we'd rather see more enforcement instead of adjusting existing norms. That is exactly what is happening here. Existing norms to be adjusted, and then especially the single permit directive and the long-term residence directive. And of course, the blue card directive, which the European Parliament is to vote on next week, if I'm informed correctly. Now, on this enforcement of existing norms, one thing. There are no preliminary references on the admission conditions for the labour migration directives, nor infringement procedures. while there's been plenty of writing, at least speaking from the Dutch side, on faulty implementation. Nevertheless, no legal action taken here. Now, from the Commission, you could say, why? Why not? That's your first tool to get member states to act in conformity. On the local level, why do local judges not refer? Well, they don't have cases, because business doesn't go to court over a residence permit of somebody who they want. But if it is that much song and dance, forget it. We'll find somebody else. So if you want, from the bottom up, enforcement of these directives, we need to, I was thinking on the way here to have like some strategic litigation group, because business is about business and not about spending money on finding out what the rights are of their workers in respect of their migration status. So that's one recommendation that I did with Kees Groenendijk in a paper we wrote on this topic. Next, when we talk about labor migration policies, be aware that they are designed to serve business. The European Commission designs them to serve migrant workers, to be attractive for migrant workers. So that is very positive. I'm very happy about it, but it's not the reality on the ground. The reality on the ground is that a business decides what happens and they decide what application to file. So now that the blue card will allow for parallel national schemes, if the salary threshold is lower in the national scheme, then that will be applied, period. Only if that scheme is not open for whatever reason to the business or the worker, then the employer might look at different opportunities. Or if the worker has a strong bargaining position and says, well, I want the blue card. But for the employer, a blue card is really not interesting, because you lose your workers after a year and a half or so. They can start moving. So we as lawyers can think that intra-EU moving is a good thing. As an employer, I'm not so sure that that would be my stance. Europe is facing great shortages in work. At least some European countries are. So we've had the battle for brains, and that's why we have a directive on ICT and the blue card and the students and researchers. But actually, if you look at the numbers, we're not so much in a battle for brains, we're in a struggle for skills. And we don't have any regulation other than, any laws other than the Seasonal Workers Directive to admit people in low-skilled jobs, practical jobs. So how to solve this? We have a lot of people in Europe. It has been mentioned in the previous session as well, intra-EU mobility should be the model, like sort of a sketch of an analogy with goods. Once they're in, they're good to go. Why not stop that? There are a lot of people who are unemployed, people who have received protection but don't find a job in the country where they have the protection. They might want to work elsewhere, but they can't. They have to wait 5 years before they can move. And if they move preliminary to that right being granted, they are sanctioned. They're illegal migrants, they're illegally employed. It's not what they're supposed to do, but they are actually doing what business wants them to do. And what the economic numbers, the struggle for skills would require them to do. So instead of shipping people from one place or another before returning them, as was discussed previously, why not see if somebody wants them for work? I'm not working for any company. I'm not a corporate lawyer. I don't have any interests in it. I'm just trying to draw another picture, another perspective, to bring that to the table to see if that will help. And why I do it is because I've worked with, for instance, and I'm not sponsored by Ben & Jerry's, but Ben & Jerry's actually did a nice project with people in the asylum procedure in the Netherlands to try and train them for entrepreneurship, either after status was granted or if they would have to return, this would give them benefits. And I think there's more business groups in Europe who might be interested to work like that. It means also that we use the people who we have. They are waiting, and waiting isn't working, so to say. It's even that if we can't move them legally, is what the employers think, what works. And then employers see, there's the services, and we can post them. So actually, you see that there's people coming in from third countries posted, which means that they have relatively, although it's increased, it's better, but still, it's a relatively simple package of social rights compared to the full equality that you could offer if you give people a single permit, which is actually on equal treatment. So this increase of services, of posting, not seeing the people that we have for the potential that they could offer in this struggle for skills is, I think, a missed opportunity if not turned to soon. Now, of course, we know that, as I said at the beginning as well, the single permit is indeed on the table for revision. Prior to the blue card being where it is right now, Kees and I suggested to add to the blue card directive a light blue scheme, which would be for the medium skilled. Why would we prefer a light blue scheme instead of what the Commission proposes, which is to add some sort of scheme to the single permit directive? Is because the single permit directive is about procedures. Yes, that's good. Equality, that's good. But it doesn't have an intra-EU mobility scheme. So if you would put some admission policy into the single permit directive, I would say also copy-paste one of the mobility schemes, either the one from the blue card, from the ICT, from the students. That's open for debate, I think. But without it, we are actually just creating a new guest worker program like in the 60s and the 70s. And it is likely to be temporary because we all fear that people who are less skilled stay longer, etc. It doesn't work. At least it hasn't worked in the past, and I'm pessimistic of the future. I will go to finish my contribution. As you see, I can go on for ages. But so, what does it get us? It gets me to the point that, my idea of this light blue is probably not coming through. I've looked at the amendments of the European Parliament yesterday, the 91 pages. I haven't gone through all of them, but I didn't see anybody suggesting something light blue. So we are indeed back to adding something to the single permit directive on admission for at least medium skilled, I could see would make sense. And, well, indeed, to cut it short, let's say that I look forward to what the European Commission comes up with, because we're still waiting for what will actually happen with a single permit and with the long-term residence. And I do welcome the initiative to have the single permit include far more procedures than it does right now, because right now it's only on the work permit and the residence permit. So the Commission wants to add the visa, changing jobs, changing permits, changing status. That's all sounds promising. But on the admission, I don't hope that a paragraph on admission stalls the negotiations on an improved single permit altogether. And in that case, I would say drop it and let business do it the way they do it through whichever country and national law they like. Thank you.
Thank you very much for this excellent presentation highlighting so many issues, controversial issues. Of course, I understand you could speak for hours, but you mentioned really critical points. And we will have the perspective from the Commission later on. But first we have a presentation about the mobility inside the Union and the added value for the new blue card. The speaker is Professor Ségolène Barbou from University of Paris I Panthéon Sorbonne. And You have the floor.
Thank you very much. And thank you, Philippe, for the invitation and also for the perfect organization with Nicole. So let me try with probably much less nuances that I would like, but it's due to time constraints. Let me try to account for the added value of one of the most important aspects of the new Blue Card Directive, which is intra-EU mobility. And by this, I very simply mean the possibility granted to highly qualified third country national workers having received a blue card in one member state, so-called first member state, to reside and work in a second member state and maybe a third one and a fourth one. So there has always been widespread agreements that enhance right, but also the possibility to move and work more easily between EU member states are the main elements that can or could contribute to win the race for talents, to put it like the Commission in the Pact. But this issue of intra-EU mobility has always faced resistances from member states willing to retain a degree of control over their labour market. In a way, flexibility remains their mantra when they're speaking about labour market. But finally, as we know, after years of negotiation, political agreement was found last spring on the final version of the recast Blue Card Directive, and as always in EU life, we have reached a compromise. And I don't want to criticize this aspect, and I just want to focus on 4 elements that I think can be deemed to facilitate intra-EU mobility. So the first one is reduce substantial condition to intra-EU mobility. The second aspect is improved mobility for family members. Third point is shortened procedural deadlines and simplified procedures. And fourth, and I will be very brief on all that, don't worry. And the fourth point is improved stability and security given to blue card holders and their family. So on the first aspect, the first improvement, I think, is reduce conditions to be allowed to reside and to work in a second member state. So a new provision was added on short-term mobility. It's the wording of the directive, and Article 20 states that blue card holders now have a right to enter, reside and carry out business activities in another member state for 80 days out of 180 days without a need for authorization. And Tesseltje mentioned the impact and the influence of business, and this provision has been really welcomed by business, and they mostly consider that it's a very good provision insofar as it ensures the continuity and development of the economic activity in Europe, but also because the option already existed for intra-corporate transferees permit holders, and there was no legitimate reason to treat blue card holders differently. But long-term mobility is also facilitated in the directive because before moving to the second member state, it is now required to have spent 12 months instead of prior, it was 18 months as blue card holder in the first member state. So the Commission was more radical. It aimed to allow blue card holders to start working in the second member state as soon as application was submitted, but still it is a progress, I think. And also as regard qualification, we can notice an improvement given that now we have reduced requirement from workers because subject to new Article 20, fourth paragraph, EU blue card holders should enjoy equal treatment with EU citizens as regard recognition of professional qualification. And this is clearly linked with the EU's attempt to widen the pool of candidates that could qualify for an EU blue card and could move. So this is the first group of provisions that I think can help supporting and facilitating intra-EU mobility. But the second contribution to intra-EU mobility comes from provisions which concern family members' intra-EU mobility. And first, and its words matter, and I think it's important, a new Article 22 of the new Blue Card Directive states that when blue card holder moves to a second member state and when family is already constituted in the first member state, then family should be entitled to accompany or join blue card holder. And I think it's a significant step. And in particular, because we should probably link that with another provision, stating that now family can enter and stay in the second member state on the basis of valid residence permits obtained in the first member state. And it's significant as it is a derogation to the Family Reunification Directive, which states that member state concerned shall authorize the entry of family members. And another exception to Family Reunification Directive can also be found in another provision, which is Article 22, which grants the possibility to apply for a residence permit within the territory and not from outside, not from the first member state. And again, in the Family Reunification Directive, it is a possibility, but it's mostly conceived as an exception. So all these provisions illustrate the importance accorded to family mobility by the EU legislator. There is a third group of provisions that I think is quite interesting and which is also aimed at facilitating mobility, because the text indeed provides shortened procedural deadlines and simplified procedures. So there is this agreement that little use of the EU blue card for years could be explained by excessive bureaucracy, and also because sometimes, not to say often, applying to national blue card schemes was perceived to be more efficient, because these cards could be delivered more quickly. So there is an emphasis on shortening procedure. And in the text, all actors, in a sense, are required to act and or to react faster. You can see that clearly for families. For example, they have only 1 month to submit an application for a residence permit in the second member state, but on their side, member states also are required to be quick, to act quickly. And for instance, just a couple of examples, the second member states have shortened deadline, 30 days, for examining the blue card application, and in a sense to force them to act quickly. The directive states that at the latest 30 days after submitting complete application, applicants are allowed to start working. So it's really an incentive to act quickly. And another example, the waiting period for family reunion is now cut to nothing if their application is submitted at the same time as the blue card application. So in this case, the second member state should issue the residence permit for family at the same time as the EU blue card. And finally, a fourth group of provision I think is worth mentioning, which improves or aims, I think, at improving stability and at providing more security to blue card holders and their family. In particular, what I think quite relevant is that the Blue Card Directive takes into consideration possible gaps resulting or deriving from non-coordinated decisions by different member states. Like in the first directive, the current Blue Card Directive starts that when the second member state will reject application for Blue Card, the first member state then will have to allow re-entry of blue card holder without formalities and delay. But another element was added in the text, because now new Article 23 states that when blue card holder moves, first member state should not withdraw his or her blue card until second member state has taken a decision on application. So we can really understand that the objective is to avoid any possible negative consequences resulting from transnational situation, and to avoid, in a sense, that a blue card holder could result, or non-blue card holders could find themselves in irregular situation. And finally, security and stability are provided by the possibility to accumulate years of residence in multiple member states. And this is important because cumulation is possible whether residence is based on EU blue card, but also on national blue card schemes, and also whether residence is granted as researcher or beneficiary of international protection or other bases. And so the conclusion of the question could be, so is it enough? And you might have noted that the title of my contribution is probably the only one than allowed to believe that some progress can be assumed to derive from recently adopted legal norms. And it is late today, but I don't want to allow you to be too much optimistic. So let me just, by way of conclusion, finish by two elements that I think allow to nuance the conclusion that intra-EU mobility is likely to be increased thanks to the new directive. The first element, it was mentioned by Tesseltje, is that we have remaining national schemes, and I'm really asking whether the very logic of maintaining national schemes is not per se in contradiction with the very project of increasing intra-EU mobility. And the second question or remark is that Blue Card Directive remains what I think can be called an immigration instrument. By that, I simply mean that the Blue Card Directive could have been, or maybe should have been, based on a different logic than other migration directives, precisely because it's a rare EU legal norm dealing with third countries that member states want to attract because they need them. And it is not the logic of free movement of workers which has been chosen. Just an example, the Commission, like the German presidency, was pushing for a system of notification rather than a system of authorization to move to the second member state, and it's not what finally was decided. And last, in the text, you can a number of provisions here and there that tend to conclude that intra-EU mobility remains perceived as a threat, in particular when mobility is between non-Schengen states to Schengen states. And so it remains clear, in my view, that the sovereignty rationale remains of primary importance, even in the context of highly qualified immigration, and the economic argument, that is to say here, increasing freedom of movement as a means of strengthening the single market, has found a very, very weak echo in the legislative work. So it's neither a fresh start nor a stalemate, but optimism is not exactly what I would choose for tonight. So sorry, I have been a bit too long.
Thank you for this, for giving us the good insight, the excellent insight into the Blue Card Directive and a little prospect of some progress made in the area. Now we will have the Commission perspective on, at the end, on the perspectives in general, but before on talent partnerships. And this is really an interesting topic where we have little experience, and I'm looking forward to hear what the Commission expects and what are the results of pilot projects and first efforts in the area.
Thank you. Good afternoon. Thank you. Good afternoon, and thank you for inviting me. I'm sorry, Chair, I cut you through. Yes, so Francesco Fusaro from the European Commission. I'm here also with my colleague Silvio Grieco, and I think some of the elements you have addressed right now will be taken later on. Now it's a little break, I think, and moving to talent partnership, the elements related to the skill and talent partners this will be taken later. Now, I want also to thank you for the invitation. The point I wanted to make is that I was here also this morning, and previously I followed the training of Odysseus, and it's a pleasure for me to be here, feel again a student having possibilities to learn. I went through the publication of blog posts, and I also wanted to congratulate the ones that have been working on this, because they have set the framework of the discussion. First of all, the legal basis of Article 79 of the Common Immigration Policy, but with the right of member states to retain the volumes of admission, as well as what it was done in the past. So the communication 2017, and then the launch of pilot projects. So this is what it leads to where we are today. And what I will try to do in my intervention is to give some more information about what we have done, the Commission has done so far on talent partnership. The first thing it is a word about pilot projects. They were funded by EU, and there was the cooperation between EU member states and third countries. So among third countries, most of the pilot projects were in Northern Africa. That showed the interests of EU member states in this region, but also in Nigeria, Senegal, and even Moldova. So some of these pilot projects came to an end, others have just been launched or are in the middle. So what we could see from what we have done so far, it was the difficulties of having such a project. So putting together the stakeholders in EU member states and in third countries, it's something that is difficult. It's also difficult to match the skills of third country national with the needs of EU employers. We have noticed that it's expensive, and the few mobilities have happened, and it is also because of COVID, but more generally because working together, it takes time. Working together in third countries takes time. So these are some of the elements we saw. On the other side, we saw also the need of creating good relations between the administration of EU member states and the ones of third countries. We have seen the ones that could come to Europe, how happy they were, how they, some of them decided, had the opportunity to stay, but others followed another career path by going back to their home country. And at the same time, we saw also unexpected partnership. So I refer to one particular project called Digital Explorer that put together Lithuania and Nigeria, where ICT specialists traveled to Lithuania and got the job there. So, but what it is talent partnership? So we say that it builds on the pilot project, and this is exactly what it is, but has also the ambition to go beyond a project-based approach. What it is said in a pact, it is that it involves several elements, so not only the mobility, but also the capacity building, and then it is a multi-stakeholder approach, so where we involve employers, trade unions, but definitely need to involve the third countries and the organization in third countries. So what we have done so far, it was going beyond to try to operationalize what is in a pact. It was to proceed to a consultation process, which took quite some time because of the number of stakeholders involved. Generally, there was a strong support. This came from business organization, this came from also member states, but the civil society that also was consulted. Of course, it was a general support, it was a support to a concept, and we are working on this, on also the advice that we have received in discussion with the member states. What it seems clear is that because of the experience of pilot project, there should be a flexible approach. So when we call this flexibility, and the word flexibility seems to be declined under several aspects. So the first one is red tape. So member states would want to have less burdensome procedure. At the same time, we have from the business, but also the trade unions based in EU, received a warning that talent partnership should not only treat the high-skilled, but also with other categories. And we also could see what are and where are the needs that were told us not only by the business, but also by the member state and also by the business. Some of the categories, so we have talked about ICT, healthcare and personal service, agriculture, construction, public transport, logistics. Then when it comes to the region, it really seemed that Northern Africa, it's something that is of interest. It was in the Pact, but it was also in the statements of member states. And that shows not only that this is a strategic region for the EU and its member states, but also the fact that there are administration and education systems that could perform and contribute to fill in the gaps of the EU labor market. However, this is not a limitation and a geographical limitation for the talent partnership, because other third countries are interested and some EU member states look farther than the neighborhood countries. The last element is about the private sector. So why I highlight that, it's because we could design partnership where there is a need for work. We need to have the support of the business to ensure that the mobilities and the experience that the third country national will do will benefit not only the companies themselves, but overall that will reflect also what is an integration process in a new EU member state. So in the conclusion, I will say that we have moved from the Pact. We are not yet in the dilemma to be dead or alive, because its talent partnership is to be born yet. The delayed adoption of the multi-annual financial framework has not helped, I must say, with the programming phase, has not helped, and does not clear the views of how this could go. So this is also to provide additional content to the blog post that were also referencing to the EU funding. So what is definitely crucial, and I saw also in your article, is to have member states on board, not only for the admission, but also to maximize the potential of talent partnership. Member states already bilaterally have their own initiatives in third countries. So an EU initiative should integrate and build on what it already exists, avoid duplication. So it is to be supported politically by member states, but also by third countries that often remark their risk of brain drain. And the reason of the political supports will lead the talent partnership to be linked to the political dialogue and the engagement between European Union and partner countries on migration. That's all for me. Thank you very much.
Thank you for giving us insight into the talent partnerships, and the final speaker will give us a short overview of the perspectives and prospectives of the reform of the immigration policy. Mr. Silvio Grieco is also from the DG Home, from the European Commission. The floor is yours.
Thanks a lot for the invitation, and I will also start from the booklet that the Odysseus network prepared. It was very interesting, and the blog post on legal migration says legal migration in the new pact, modesty or unease in the Berlaymont. Now, I work in a much less fancy building than the Berlaymont. Anybody of you that came to the DG Home building knows that. But I can try to address this question straightforward, saying that it's definitely a modest reform, the one that the Commission is going to put forward. But I mean, I believe that modesty is a value, and definitely it's the best reform that we can get now, given all the constraints and circumstances that we have now, that I will try to explain. Now, this conference is, of course, a follow-up to the Pact, or to see what's the state of the implementation of the new Pact on migration after 1 year. But when it comes to legal migration, the starting point, it's before the Pact. I mean, when it comes to this reform of legal migration, the starting point is the fitness check that we carried out in 2018, 2019. This fitness check was an overall evaluation of the EU legal migration acquis that was presented at the beginning. So the 7 legal migration directives that we have. The purpose of this evaluation was indeed to see, so after almost 20 years of EU legislation and EU common policy on legal migration, what's the state of the implementation? Is it efficient? Is it effective? Is there really an added value? Of course, this was a very complex exercise with a very complex conclusion as well. There was no easy answer. Well, it works or it doesn't work. Let's say that this evaluation found that many aspects of the EU legislation on legal migration, they work, they improved the situation of the country nationals in the EU, the situation of the country workers, the needs of the employers, what was also mentioned today. But of course, this is a patchwork, this is a fragmented system that definitely there is a big room for improvement. And this is why we are working on this modest reform. This was announced in the Pact. In the Pact, the Commission states that we will come up with a skills and talent package with 3 different measures. So it was already said, revision of the long-term residence and single permit directive, plus a non-legislative measure, which is the EU talent pool. It's not an overall legislative reform of the system. It's not an immigration code. This is, as you all know, a very complex and sensitive area when it comes to the EU harmonization. We know that there are many different views on what we should do in this particular area, and we need to address all these different views. And this is also why, and what we are doing actually now with the impact assessment process of the revision of these 2 directives. Now I know that one of the main criticism from academics, but also from the European Parliament and other stakeholders on the reform of the common asylum system was that there was no impact assessment, and there are various reasons for that I'm sure they were again explained today. In our area, we decided that it was good and appropriate to have a full-fledged impact assessment on the revision of these two directives, and this is something that we are completing now. Normally, the proposals, they should be adopted by the Commission towards the end of the year or maybe at the beginning on next year. So the process is almost final. Now, the impact assessment is a very complex and also painful process. I mean, say it from a bureaucratic point of view. But it's also very useful and interesting for different reasons. Probably the main reason is that there is an extensive consultation process that we do when we do impact assessments. We really, when it comes to the revision of these two directives, we really heard all different views, starting, of course, from the views of the co-legislators, so the member states, the parliament, but then we had the public consultations, we listened to civil society, organization, trade unions, and they all have, of course, different views on these two directives and more in general on the development of the EU legal migration process. Now, of course, I cannot tell you what will be the end result of these legislative proposals, because this is something that is not finalized, and it's of course the Commission that adopts these proposals. But the objectives of the revision of these two directives are clear already from the Pact. When it comes to the long-term residence directive, the two main problems to be addressed are the underuse of the EU long-term residence status, because there are national parallel schemes, the same problem that we saw with the EU blue card, and the underuse of the intra-EU mobility rights from the side of the long-term residents. So the fact that there is possibility for intra-EU mobility, but there are many barriers. This is not used to an effective extent. And we are going to address this. Of course, there are many technicalities in this, and maybe I would add that something that we are looking into is also the conditions to acquire the status, because also there are many barriers. Many stakeholders say, for example, that 5 years is too much, or that the integration requirements and the resource requirements are too difficult to meet. These are all things that are being assessed and we will address. Now, when it comes to the second directive, the single permit that was mentioned more extensively in the introduction, this is, again, a very different directive because it's an horizontal one, doesn't include admission conditions, only procedures and rights. And we saw, though it is not as old as the long-term residence directive, which is from 2003, the single permit is from 2011, but we saw many implementation issues, complaints. We also have infringements and preliminary rulings on that. So really the objective is to make it work better. So to really have a single permit, a single application procedure, to include also the visa procedure in there, and to improve the rights of third-country workers, because there is the issue of the risk of exploitation, which is not directly addressed by this directive, though of course there are the equal treatment provisions that also aim at avoiding this risk of exploitation. Then there is the big issue of the admission conditions for low and medium skilled, which are the ones that are not currently covered by EU law. This is something that is being assessed in the impact assessment of the single permit. We heard from Professor De Lange the criticism on adding, the argument that probably it's not the right place, the single permit directive, an horizontal directive, to include admission conditions, that it would have been better to have those in the blue card. We are aware of this. We are considering everything. We are listening to the views of all the stakeholders, and yeah, we will come up with concrete proposals very, very soon, and you will be able to see in the impact assessment reports the process really that we have done in coming up with these proposals. Now, the last point, which is the last measure that was announced in the Pact, is the development of an EU talent pool. or rather setting out the options for developing a new talent pool. This is not a legislative proposal. This is something that the European Commission has started reflecting upon since a few years together with the OECD, because, I mean, we also heard this at the beginning. The EU legislation rather focuses on workers, so on emission conditions, workers, or third country nationals in general as other category, but doesn't do anything about the matching of the workers or people that want to come to the EU with the needs of the EU employers. I mean, if we talk about labor migration. And this talent pool, the idea of having a EU talent pool is really to have a tool that would help this matching and this international recruitment. Now, it's a very nice, it sounds like a very nice idea, but of course it has many technical complexities, and this is why we asked the OECD to carry out a flexibility study to see really concretely what we can do to establish this platform at EU level, what will be the scope, how it will be linked to the EU legislation or national legislation, and this is something that we will tell in this package. There will be what we call a chapeau communication, so a communication from the Commission to accompany this package, but this is really a starting point. We're not going to launch a website with the EU talent pool, but it's really a starting point to develop such a platform. I will stop here, and I very much look forward to questions and comments. Thanks.
Thank you very much for analyzing the perspectives of a reform. We see it's neither perhaps a real fresh start and no installment, but it's work in progress, I would say. We are late already, but if there are questions, of course, I will allow them. And I also follow the tradition and ask if there are any online questions.
Yeah, we have two questions online from Alberto Neidart from the European Policy Center. And the question is, what was the thinking behind the choice of reducing the 3 years, the waiting period to qualify for the long-term resident status under the reform of the long-term resident directive? And this 3 year period, is it a compromise? And is it a reflection of the waiting period in many national schemes? And this question is mainly for the two representatives of the Commission, Mr. Grieco and Fusaro. And then a second question to Professor De Lange, still on the long-term resident directive. And the question is it enough to reduce the waiting period for the acquisition of long-term status to achieve intra-EU mobility, other than and what else? Yeah, other than a shorter time period is needed or can be done to facilitate intra-EU mobility? Thanks.
Thank you. I would say I collect the questions and ask to raise the questions, and then we have a final round of answers. I saw your hand, and then I have Daniel and Paula.
Yes, thank you very much. I'm Jérôme Vignon from the Jacques Delors Institute. It's late, but I will rather venture a question to Professor De Lange. There was an allusion by Silvio Grieco to the OECD contribution to shaping the legal migration policy of the EU. One of the criticisms made frequently by the OECD to the present state of the legal migration framework in the EU is that it incentivizes illegal migration, in that sense that potential candidates for working third country nationals in the EU must demonstrate that they have a contract or they have found a position before the case being evaluated. So as long as they have not reached the EU territory, it's very difficult for them to make that case. So the question, a few decades ago, I think the Commission had envisaged the possibility of granting working and residence permits for third country nationals searching a job in the EU. This would have been temporary permits, let's say 6 months, 12 months, and certainly would have constituted an alternative to illegal working migration. Do you think that this makes sense, or is it a totally foolish idea?
Daniel?
No, thanks. I happen to be the chairperson of the advisory committee on highly skilled migration in Germany, and that is not irrelevant because 80% of the blue cards are handed out by German authorities. And I have 3 very short observations of the kind of arguments I hear from stakeholders, various stakeholders in that committee, and they contrast a bit with what has been said today. They tell me, firstly, it's totally irrelevant for us whether these people get a national permit or a permit harmonized by EU law. What we care about is that they get a work permit in Germany and that they get it quickly and that they do not have to wait 6 months for it to be delivered. That's the kind of thing they worry about. They worry about lengthy procedures and not about whether there is an EU directive in the background or not. To the contrary, you can be sure that the next German government, if you read the election material, will come up with new proposals in the field of labor migration and for skilled and highly skilled and medium skilled. And if you ask politicians involved in these debates in Germany, they say, be careful with that EU harmonization because it can be a straitjacket. Directives are extremely difficult to amend. And if we have innovative new ideas how to respond to the shortage of workers in Germany, we want to be able to pursue them, and if it's not within the framework of the blue card, so be it, but we get the workers. And the second kind of argument I hear, intra-European mobility. Both the companies and also the people advising the individuals, the highly skilled migrant, tell me, I will never go through that highly complex intra-European mobility procedure. If I have someone working for a bank in Frankfurt who wants to work for another bank in Amsterdam, I just call my colleague in Amsterdam and he organizes a Dutch permit, be it a blue card or a different permit. It's just, there is no practical need to go through this complex transnational channel because if it is really the highly sought after person, he will easily get a new permit in the Netherlands. And that debate in Brussels about intra-European mobility is academic, they tell me. And I'm the academic, of course, and then I defend the European perspective because I'm a good EU lawyer and a committed EU lawyer. And thirdly, and that also the trade unions tell us, we really have to distinguish whether we talk about the highly skilled or about seasonal workers or then about talent partnerships, which is also about the medium skilled. So this concern, this very important concern of protecting the rights and interests of people is very relevant for the medium skilled, but for the highly skilled, it's not that relevant because they usually get what they want anyway. And if they don't get what they want, they don't go to that country in the first place. And in the German debate, I mean, they got all the rights they want because, why? Because a German business tell the government, you give them family reunification right away, otherwise we do not get them, and we need them because they fill the vacancies we need to fill.
And then the final question, and then I will ask the speakers to respond or to conclude. Paula?
Thank you, Ulrike. I'm Paula García Andrade, Associate Professor of EU Law at the Universidad Pontificia Comillas. Thank you so much for this interesting panel. I have 2 brief questions to Mr. Fusaro about talent partnerships. I'm really interested in these instruments. And the first question would be, when it is said that, and you mentioned that mobility or legal migration schemes would be part of these partnerships. What kind of mobility of legal migration is envisioned? Whether we are talking about EU schemes in connection with EU legislation on legal migration or just a union support to national ones? And secondly, what form are these partnerships to take? Are we thinking of agreements or soft arrangements with the third countries' authorities, or simply an EU instrument? I guess even hard or soft, there would be a kind of arrangement with a third country to honor the name of partnership. Thank you.
Yep, thank you. I will allow another question. Philip has a question.
Very briefly, well, we had a very provocative position expressed by Daniel, and I link that to the idea of the Commission to propose something about non-highly skilled workers through the Single Permit Directive. Well, actually, the format is not that important, but I have to say that I found this idea quite surprising due to the fact that for highly skilled workers, it is already extremely difficult to adopt a directive. I was very impressed by listening during the summer school to a debate when some observers from Council and Parliament said that it has been that difficult to reform the blue card that at one moment there was a risk to fail, even on such a directive. So it would be very interesting to see what the Commission will come up about non-skilled or medium-skilled workers, but will the member states ever buy that? And then a second question is about the talent partnerships. We have very few actually information about these pilot projects. I never read more than one on another footnote of in a Commission communication, but on a website I saw one of the projects which is implemented by ENABEL, which is the Belgian Administration for Cooperation, and I read there that I don't remember exactly the figure, but that the project that they implemented with Morocco was about, I might be wrong, but 120 persons. So then I think that with those pilot projects, there is a question of scale, and it might be the case with talent partnership. Are we going really to work on those micro projects? And does this make sense when you think about actually the need of the European Union in the future of a lot of workers when you see the shortages on the labor market? Thank you.
Thank you very much. I heard there is one more question online. Is it a short question? Then you can present it. And then I don't intervene again. I ask the speakers in the order they spoke to respond, and I ask you to be quite brief. There are so many interesting topics, but at the end we should try to concentrate on the most essential points.
Yeah, we have just a follow-up question about talent partnership. And due to the fact that in the pilot projects, only Belgium, Spain, Italy, and Lithuania participated, how does the Commission intend to act to encourage participation from other member states? And the question is for Francesco Fusaro. Thank you.
Right. Thank you very much for the questions. First, from Alberto. Is it enough to reduce the waiting period? No, it's not. 3 years is nice, but the conditions to move are too restrictive, especially the labour market test that can be applied during the first year. But also for the self-employed, it is vague from my experience, and I'm talking about recent case law, 8 cases from Dutch district courts, all ruling sort of differently on the kind of proof you have to prove that you are self-employed. And I'm working on this. I will translate them and send them to you guys so you can take this as an example of something that should be better. Another thing is that right now, the Long-Term Residence Directive doesn't require the member states to mention on the residence card that somebody is a mobile long-term resident person. And that means that you don't see it on their status. So if somebody comes as a self-employed person, they have a status as self-employed person, not as European long-term residents using his mobility rights. Thus, all the equal treatment clauses that the directive provides are waived by ignorant people, and don't blame them, the ignorance, because they don't see on the residence card what the rights are. So how are they going to give them the extra rights that are indeed granted through the directive? So reducing to 3 years is not enough. The question on the OECD and legal migration and that it incentivizes illegal migration. Well, if there's people here, they have friends and family who might also want to be here. So if that can't be done regularly, it might happen that some friends and families come for visit and overstay. So it's a question of balancing the interest, I would think. But as such, that's business as usual. So creating more legal migration pathways would not necessarily would add to this, but I find it hard to see the link. The suggestion was, instead of irregular migration, to come with for a search period. Of course, we have that in the Students and Researchers Directive, a 9-month search period for those who've finished their qualifications. I'm not so sure if it makes sense to extend that to anybody who cares to come and find work. When you design these kind of policies, it's not just, and I hope my previous intervention made that clear, it's not just the business interest that you should consider, it's also the migrant interest, but also the society's interest. At some point, the neighbors are just not inclined to be welcoming to newcomers. And if you, however welcoming I would like us all to be, and we've talked about solidarity and solidarity of states, but there's solidarity between neighbors as well, and you cannot push it too far. If I may, one more on the highly skilled. Daniel, thank you for your intervention there. Good to know that you're on this, that you're chairing this committee. I have a lot of questions for you. It's good to know that business doesn't care, and it's exactly what I fear, that they don't care. But what migrants care about is about getting this long-term residence. And if they have 2 years in Germany on a national permit and then 2 years in the Netherlands on a national permit, that gets them zilt. While the good thing about the blue card is that if they add them up eventually, they have long-term residence and they are freer to move, to pick other jobs, etc. And a lot of long-term residents, a lot of high-skilled migrants are not necessarily coming for the job. I know of a lot of Turkish, Ukrainian people who don't apply for asylum for whatever reason, but who do not want to go home. And having a job as a high-skilled person is their asylum way. And if they lose it, if there's a gap, if there's uncertainty, it kills them. And well, not literally, but emotionally. And I've spoken to people, and I find it worrisome. And I think that's a good thing that legal migration has to offer. They're just here to work. They don't go through the whole asylum song and dance, but it does mean that they need a secure residence status. And national policies do not always add up to this security on the long run. And I love the pilots. Philip, there's in social science reports on these pilots. It's about 49 people, 100 people, 120, and each time it's about $1 million that it costs. They stay temporarily, they don't get their visa on time, they have to go home. And this is a question for me, and then I'll be quiet. To the Commission, where what was it? I took a note. You said they follow another career path. I think it just means that they're temporary schemes, and they're really about development and not about migration, and the development is supposed to take place there and not here. So I don't see it as a migration instrument, but correct me if I'm wrong. And the final thing, can we stop talking about business needs? It's business demand. There is no need for migrant workers. There's a lot of other ways to do it. All these vacancies and getting people in, I'm perfectly fine. It can be that we need them to innovate so that we can handle the demographic changes that we're up to and the environmental changes, etc. But business needs are often short-term, postponing investments in more structural changes. And I think looking at where we are with the sustainability of our environment, I think that should be part of the discussion and not just needs. Sorry, this is something I had to say. Thank you very much. I look forward to the other comments.
Do you want to comment, or do you want to, was a question raised towards you? So you can take the floor. If you, Ségolène, would you say something? Okay. Microphone is on.
Oh, sorry. Yeah, just a very quick reaction to Daniel's comment and provocative thought. Well, very briefly, I fully agree that what you explained confirms that having parallel national schemes is highly problematic and is probably not a main flaw, but the main flaw in the system. And surely we have not enough reformed the EU blue card to convince stakeholders to choose EU blue cards rather than national blue card when the national system is efficient, which is probably not always the case. On the second aspect, which is intra-EU mobility as being probably an academic issue, an academic discussion, which is not necessarily a bad element, but I will remain on this level of the academic discussion, and I will here borrow from the paper written by Johan Rochelle, and who's offering a philosophical perspective on the reform, on the proposal made by the Commission and the political agreement. And he was, I think, very rightly insisting on the fact that reforming the Blue Card Directive is not only a question of interest, and we should probably depart from a purely utilitarianist vision, and we also have to consider, and I think it's really relevant for this issue of intra-EU mobility, we should also take into consideration the issue of right. And I think he's rightly connecting the issue of intra-EU mobility with fair treatment that the treaty itself grants to third country nationals. So if I take seriously this argument, I would say that although it's part of an academic debate, it's more than that. It's very important for a third country national, and I would not take the only vision of business. I know that it's not what you're doing here. But just the last point, still I agree that it remains amazingly difficult to imagine to have a real system of intra-EU mobility while we remain with very, very fragmented labour markets. And so it would probably remain a difficulty we cannot tackle, but we can improve the situation a little bit.
So I asked the other two speakers in the order they spoke. So Francesco first, and then Silvio was the final word, and I ask you to keep your answers short as time passes by, and we're all a little bit exhausted, I suppose.
Yes, sure. So I will be telegraphic. Millions against few mobility, that is true. But this is pilot. So this is the first thing I think we have to take into account. The second element is we don't divide the investment of the funds per the people that have moved to Europe. And that is because the structures of the cost of such a projects are very different. Actually, the mobility are the one that costs the less. Putting together the companies, trade unions, administration in EU member states and third countries, it is the most difficult part. Now, this project, this pilot project so far, but this is also something that I believe will be in the future of talent partnership, provides pre-departure training, not only for the ones that will come to Europe, but will provide trainings to more people. And that is because there is a need, and we have seen the need from third country of training more people, also for the benefit of their labor market. Then when it comes to, it is a migration, it is development, I understand what is the point on the circular mobility. However, I would add even another element. Is it an employment process? Policy is a migration or development. So we try to, with a win-win, we try to catch all of them, and we have to see if this is possible. The idea is that to be flexible, so where there are the needs of short-term, we will have short-term activities, and on the long-term, we could have also longer-term activities. What I could say is that for us, for the public authorities and for the businesses, it's much more of interest a long-term migration process, because the employers are interested in investing in people, and so they wouldn't do it just for short schemes. Some areas do require just circular mobility. Now, and I refer, for example, to agriculture. Now, when it comes to are these micro projects? Yes, they are, but the other element to note to me that I will note is really about the element of the partnership. So the goal is not only filling the gaps of the labor market in Europe, but also to provide assistance and capacity building in third countries. And I make an example, and it's in the health sector, in the period that we live and we have been living. How about, instead of having 100 nurses, how about having 2,000 from Tunisia, and what would have been the impact of that? So we have to carefully see what are the needs here and also in third countries to achieve what we would want to achieve and then avoid brain drain. Then the last point, or better the last two, what are going to be look like? Well, this is an arrangement on between member states and third countries. It is an EU instrument. It will not replace what it already exists on bilateral schemes, because member states have their own interest, and probably, as for example the case of Spain and the relation with Morocco and the seasonal work in the agricultural sector, this is not probably going to come into question. But our role, it's also to see where are the needs of other countries that have not had experience with this, and how certain schemes could be more of a European level. And that's why today I started with the example of Lithuania and Nigeria, that this was absolutely unexpected to us. And when I go to the countries that have been experienced in the pilot project, we have missed in the list Germany, that has quite a huge role into this in several projects, but also including the TAM project, that also has a strong experience with the bilateral partnership, for example, with the Philippines, and that will also share the best practices of their experience. And the last, very last, another country that we have left is Slovakia, and this is also was unexpected. So Slovakia has agreed and was keen of launching a pilot project, in this case with Moldavia in the ICT sector, but this is also to see that there are other countries, other regions, and there are some regions, instead than looking to the southern neighbor, they look even to the eastern neighbor. Thank you very much.
Yeah, I go straight to the mic, and I'm not to say that I'm going to be short, because that is never true when one says that. So a clarification on the 3-year period. For the acquisition of the EU long-term resident status, it was the first question. There is not yet a proposal on that, because of course the revision of the long-term residence directive is yet to come. There is a proposal to reduce this period to 3 years for beneficiaries of international protection. That was done with the Pact, with one of the asylum instruments. And the reasons why it was included there, it's very specific to the situation of beneficiaries of international protection, because for what it was said here, so that they are less stuck in one country, in the country of protection, and they can get the EU long-term residence status quicker and then move more easily to another country. So that was the specific issue. When it comes to the general condition to acquire the ULTR status, we will see what is in the proposal to revise the directive. Now, then when it comes to the argument that directives are difficult to amend, and that's why member states, they don't want harmonization because they want, I mean, national authorities and businesses, they want flexibility when it comes to labor migration. I mean, it's definitely true, we understand, but I think it's also a bit of an excuse sometimes, because here we are talking about, I mean, in the field of legal migration, directives, not regulations. I mean, directives which are very open to implementation. So they are flexible instruments by default, the directive. Then it depends on how you build them. So I think there is always a possibility to develop a directive which harmonizes, which has a minimum harmonization, but still includes some elements of flexibility that, when it comes to labor migration, are needed. And then, there are always the instruments of implementing or delegating acts that could be used in these policy areas. They are not, but could be used. Last point, the admission conditions for the single permit. Philippe, Professor de Broeker, said that he was surprised to see this, or to hear this as a possibility to include that in the single permit or in general. So admission conditions for low and medium skilled workers. Well, again, this is subject to the impact assessment. There is no conclusion yet. Definitely, we have a good lesson learned from the Blue Cards negotiations on how difficult it is to find a compromise in the Council, first of all, on labor migration, and then, of course, between the two co-legislators. So it was difficult for the highly skilled, highly qualified. Of course, it would be extremely more difficult for the low and medium skilled. We know that. That's a lesson learned. We'll see. We'll see the conclusion. And I will stop here, and yeah, thank you very much.
Thank you all, the speakers, the participants, to stay until the end and to follow the interesting questions and discussions. And I conclude for today. Tomorrow the program starts at 9 and the welcome starts at 8:30. You will have coffee and drinks in the morning. So have a nice evening and see you tomorrow morning.